There you go. All right, wonderful. Thank you so much. We're excited to be here today, and we have a lot to cover, as Jaffre said, so we're going to be swift. Please, those on the webinar, please send in your questions. Those in the room, feel free to raise them. We're trying to make this as interactive as possible. And if you raise a question that we know we're going to hit later on in the presentation, we'll let you know that, and we'll address your question at that time. But please, like I said, this is about you getting your questions answered, as well as learning a little bit more about GDPR and where you are today with the new deadlines. So with that said, let's start. You have today, as of today, there are 3 months and 3 days, and there's also 3 rules. So prepare to shift your paradigm. GDPR brings to the table a whole new set of rules and outlook around how we handle data privacy. It is challenging the entire world to raise the bar. So this is something that you have in your head when you start your process, is that your paradigm is going to shift. You're going to be able to leverage what you know and what you have already. That's the second rule. So that's the good news. You're not going to have to start from scratch. But you also, the third rule, are going to have to fill in the gaps. So let's start from the beginning. Quick history lesson here. The EU Data Protection Regulation, GDPR as it's fondly called, was adopted by the European Parliament and the European Council on April 14, 2016. It replaces our fondly known 95 directive. So this is building on a legacy of 20 years of more than 20 years, actually 22 years, of data protection legislation that all entities, including in the U.S., are very familiar with. Basically, what the GDPR does, the 95 directive did not, is that it actually gives the EU resident. We're going to talk a little bit more about what does that mean. The data subject is what the phrase of the term of art. It gives each individual more control over their data. And the deadline for compliance is May 25th, 2018. As I said, 3 months and 3 days away. So the question then becomes, does the GDPR apply to me? And this question comes up all the time, especially here in the U.S. It casts a very wide net. So the assumption is there's a good chance. The first prong is that if you're an organization that's operating within the EU, are you incorporated there? Do you have a physical location? Do you have servers? The second prong is organizations outside of the EU that offer goods and services to individuals in the EU. And so that means EU data subjects, which are EU citizens, residents, but it also means technically right now, as broadly interpreted, vacationing Americans. If someone is on EU soil and they actually give you their data as part of their experience within that jurisdiction, then they're covered under this regulation. It doesn't apply to activities such as EU law enforcement directive, which actually has its own set of rules to deal with data privacy. It doesn't apply to national security issues. Again, there's a whole new set of rules around that. And then also for purely personal and household activities. And so basically, if you're doing anything commercial, it's going to fall under this rubric. All right, so then the question then becomes, what is personal data? And basically, it's any information that directly or indirectly identifies a person. That means names, ID numbers, location, data, online identifiers. We actually are used to that. We're accustomed to those as being part of what is defined as being personal data. What's now being expanded, though, are things that are much more intangible, such as generic and biometric, economic and ethnicity, culture, sexual orientation, sexual identity, race, all of these things that actually are beyond what well, race is not, obviously, we've been tracking race, but by way of example, economic status is not something that one actually necessarily tracks right now or deems to be personal information. So with that said, then the question becomes, all right, you have your personal data. Who does it apply to? It applies to your employees. It applies to your customers, your potential customers, your suppliers' information, your partners, and even your contractors' personal data. Any personal data that you collect through your system. And it's automated data, as well as it can also be manual file data if the manual file data is part of an automated system. So if you have a filing cabinet, but somehow it's part of a workflow that actually also has technology attached to it at some point, then that manually filed data could also be swept under the GDPR. All right, so the limitations on processing protected data, as it's stated in the under Article 9 of the GDPR, is that basically they take corralling personal data, or quite frankly mining personal data, as also having implications under the GDPR. So you cannot take a pool of information to try and figure out if you can, what someone's political opinions are, or what their philosophical beliefs are, or what their sexual orientation or their sex life is about. These are actually explicit statements under Article 9. Exclusions for using your data pool include, so in other words, if you do decide that you need to mine your data or manipulate your data for reasons such as regulatory reasons, you might be an HR department and therefore you have to be able to find out certain information about your employees. If you have an obligation to actually manipulate that information, or if you have otherwise authorized under otherwise authorized under EU law, that also would apply. And then, of course, explicit consent. There are a number of other exclusions, and the art of figuring out what information you can process and not process actually is complicated, and it requires that you sit down with a lawyer to figure out exactly how are you going to present yourself from a processing perspective. What information are you going to argue in front of the EU that you have the right to own and manipulate? You should not at this point be hanging on to information that you do not have a legal right to. And that actually is a little bit of a different spin than how using data today actually manifests. Because quite frankly, we collect a lot of information about a lot of folks, and when you actually talk to folks who are in the business of actually mining data and things of that sort, they don't use it all, right? And they don't need it all. It's actually, they just collect all this information. I may not really need your email address, even though I have it. I mean, that's perhaps not the best of examples. But I may not need to know whether you're male or female, by way of example. For the business that I do, it's not relevant to my database, but I do know it. So the question then becomes, well, why are you collecting that information if you don't need it for your business purposes? So that is one of the new things that you're going to have to be able to make adjustments around. The last thing is that as anybody who actually does any mining of data knows, that a lot of data, when it goes into the system, is actually anonymous because of the fact that you have thousands and thousands of records, or and you can't really figure out whose identity it is because of the way that the information is bundled or tagged, or you may have intentionally anonymized the information, again, for various reasons that have to deal with your business purposes. When you have anonymized data, that actually gives you a little bit of a break under the GDPR. It is seen in a different light because what the EU is saying in that situation is that, all right, you've anonymized it. There's less of risk of infringing anybody's data privacy rights. But at the same time, you still have to be compliant with the data protection rules. So it's it's a nice thing to know about when you're dealing with how you're going to use the data that you have in your environment. All right, so then the big question is, what happens under non-compliance? And so just to kind of walk you through that, each EU member has the right to become its own supervisory authority. And as a supervisory authority, it gets to certify anyone who's in their environment. It gets to investigate them, hear complaints from data subjects, and also grant injunctive relief to them. They're all empowered for their particular jurisdiction. So if your servers are sitting in their jurisdiction, or your offices are sitting in their jurisdiction, or you have data subjects in their jurisdiction, they have the right to question you, investigate you, examine your books and records and the like around how well you're protecting your data under GDPR. There are two sets of fines associated with GDPR, both of them hefty. The first one is has to do with technical fines, like breach notifications. You did not send out breach notifications in a timely fashion. And under those circumstances, the fines are the greater of, which is also another scary phrase, but the greater of 10 million euro or 2% of your annual revenue, not review, revenue. So sorry about that. But on the flip side, it can get even greater for non-technical activity. And when I say non-technical, I don't mean it in the sense that it's not based on technology. It just means that you actually, as an organization, haven't been adhering just with the spirit of GDPR, and therefore have placed yourself in a compromised position, which actually has a greater fine associated with it. And that is 20 million euro or 4% of your annual revenue. So just to give you a sense of what they're talking about when they say non-technical, they're talking about things like the depth and the length of the infringement. How long have you been not adhering to the GDPR around protecting data subjects' privacy rights? How long have you been letting it go on without being compliant? Was it done intentional or was it done through negligence? How proactive were you around mitigation? And then also your organization's just general GDPR preparedness. You know, right now we're finding that a number of institutions right now are kind of in the wait and see mode. Some are in some institutions are raring and ready to go for May 25th, and others are kind of like overwhelmed, even with the best of intentions. They're like, oh my gosh, there's just so much here. Well, the reality is all of those nuances of where you are when this infringement happens are taken into account. So quite frankly, the one that says, you know what, who cares, is going to not be as seen as well in the eyes of the supervisory authority as one who says, we've been trying, we just couldn't get our act together as quickly, but we've been trying, and this is how we can show you how we've been trying. So it's best to make an attempt at it as opposed to ignore it. And then other things that also come into play around non-technical fines are history of infringements. If you keep coming back and like, dude, this is like the third time you have had an infringement when you're still not fixing it, that's not going to bode well for you. And the last thing is cooperative action. And what they mean by cooperative action is basically, are you pleasant with the regulator? Are you are you trying to learn from your mistakes? Are you telling the regulator in a timely fashion? All of these are commonsensical things. Anybody who's ever dealt with a regulator understands all of these nuances, but this is where the higher fines around non-compliance come in. So the EU expects you to be a positive player in this space when it comes to your own compliance. All that said, the question still comes up. He says, all right, basically, I live in the U.S. How the heck does this really apply to me? And as I mentioned earlier, this is the GDPR is based on the 95 directive. The 95 directive, as you know, has been here since 1995. I said 22 years ago. And during that 22 years, we have had a very robust, in our court system, a very robust honoring of what is called under legal terms long-arm jurisdiction when it comes to the GDPR. And basically what that means is that U.S. courts have honored and recognized the EU 95 directive as being valid legislation if it actually if they can prove that there's a connection between the two. So it's not as though under U.S. courts we just throw out the 95 directive. We have not been throwing out the 95 directive, and so the question then becomes, well, if they're not throwing out the 95 directive for 22 years, and this is based on the 95 directive, again, the logic would be behind that when on May 25th, that the U.S. courts are still going to honor long-arm jurisdiction for the for GDPR. The second thing that also we don't have as much control over here in the U.S. is that data subjects now have rights that they get to enforce. We're going to talk about that a little bit more. But basically, they get to go to their supervisory authority and say, or to you, depending upon which route they plan to take, and say, they took data from me without consent, or they may say, I want to be forgotten, the right to be forgotten, so that they write you a letter and they say, listen, I want you to erase all my records, and you have a certain time period in which to do that. Or they may say, I want a copy of all my records, I want to record it with me, I want to take it with me. They have the right to ask you for that, and you're supposed to supply it. And then also the data subject has the right to come to you and say, this is wrong data about me, and you need to correct it. So even being in the U.S., we're not going to be able to get away from having EU data subjects write us and say, I want these 4 things honored. And so you're going to be getting, you're going to be in this position where you're going to be receiving these letters, and then you're going to have to be able to prove why you don't have to be compliant. And again, that flips back to making certain that you have done proper legal review around how you process data, and do you actually have a legal right to process that data under the GDPR. So that's a lot of information before I move on. I want to make certain, is everyone kind of comfortable? Any questions?
Can I ask a question?
Absolutely.
What is their enforcement capabilities? And maybe even a different way of asking, what is the probability that a small or medium-sized U.S.-based business that maybe markets in Europe will actually receive an enforcement action?
Their enforcement abilities right now are mandated by this legislation.
Yeah. What's their stretch? What's the capabilities? Are they going to start employing tens of thousands of people out there to come after small little companies in Norman, Oklahoma that might be a violation?
I don't know where their appetite is going to be and where their bandwidth is going to be, but you're absolutely right, and probably let me say that I imagine that there will be some sort of prioritization as to who they go after first, second, and third. But the reg right now does mandate their ability to send you a letter. There's no question about that. If you are hitting on any of these prongs, and as far as the data subjects themselves, again, to the extent that they are aware of their rights, they could easily be sending letters. There are stats right now where they say that that data subjects in the EU right now it ranges between about 40 to 50% of them actually know what the GDPR is. Okay. My concern is that I think that on May 26th there's going to be this lovely cottage industry of nuisance suits that are going to come up because there are going to be people who do get it, and that we're all going to have to scramble to figure out how to actually address those nuisance suits. And I do think that there is going to be, just as there is right now with phishing and all this other kind of stuff, I do think that this is going to turn into some form of revenue model for somebody out there,
Well, it's already turned into that. to a certain extent,
Consultation.
Yeah.
right? I mean, we're all here for a reason, and
I-
then afterwards.
I was wondering if you think they're going to basically go after a big fish and someone who makes
Yeah.
a lot of revenue,
Mm-hmm.
and they're going to set an example and do a shock and awe campaign, and now everyone's going to start trying to fall in line.
When,
You know,
Mhm.
I don't see a big attempt for. Well, maybe your company is doing it, but I don't see a lot of outreach from other companies saying, "Hey, you need to be focusing on this. Let's engage all of the legal counsel in these small, mid-sized, medium companies and start getting them thinking about this, like Y2K, if you will."
right.
I don't see that happening yet. So I think what's going to happen is it's going to go into effect. They're going to make an example of someone, and everyone's going to start waking up. And
I think that's probably the approach that's going to happen. Whether by design or by default, but because that's usually what happens. Exactly, right? Because once you have the Equifax example, then boom,
Yeah.
everyone else has to. Yep,
I have two questions.
Mhm.
Data subject, is that an individual or an entity?
individual.
And as an individual, you would be representing yourself. So, like, for example, in product development, they collect information about you to craft and create products. So, for example, with like wealth management, they're collecting demographic information so that they can propose their products. So, is that in scope as well?
Yes, that's exactly the target, actually. And as far as, will these data subjects actually start getting legal representation? Who the heck knows? But really, these are such narrow requests. You're supposed to actually, and Ash will, in his section, actually talk to this more, but you're supposed to have technological tools at the ready so that folks can, with a click of a button, ask for things to be erased within a time frame, ask for things to be ported, ask for things to be rectified, so that you're actually, your technology has to be data subject friendly, so that they don't have to jump through a lot of hoops to be able to get their rights enforced. And the same thing with also getting explicit consent. Any other? Yes.
What is the purpose of the enactment, and do you think it's necessary?
As a privacy lawyer, yes, of course I think it's necessary. But the purpose of the enactment is really to allow for the fact that right now using other individuals' data has become this huge industry. It's actually where most people make their money if you actually pay attention at all to data mining and data analytics. And the EU, from the very beginning, if you were to look at the history as to how both the U.S. and the EU have handled privacy and security, the U.S. has approached it from a technological perspective first, and then privacy came second, whereas in the EU, privacy came first, and then technology came behind it. So that so their mantra has always been about protecting individual rights from 1995, and this is just now an outgrowth of that trajectory. So, and I didn't mean to be so glib, but around, do I think it's important? I do. I will tell you this. This is a very broad regulation. And so it's going to take a while for folks to really be able to find their way through it. I don't know how you could have drafted it more narrowly, given the problem they're trying to solve. I can understand why it's written the way it is, but it's going to there's going to be a learning curve for the EU, for the legal community, the tech community, and for actually every individual, because right now they are just learning what their rights are. And once they figure out how to exercise the muscle, as this other gentleman had pointed out, then I think it's going to really start to actually be an escalation of issues,
Do we have anything in the U.S. comparable to 95?
We are actually looking to put together data privacy parallels. New York State has one that's actually about to supposedly supposed to pass the assembly later this year. And at the federal level, there's also conversations around creating a data privacy legislation. We have something called Privacy Shield, which actually is a way of giving U.S. companies a safe harbor that's associated with GDPR, and that's another thing that we have. Well, it's really associated with 95. We have to figure out how it's going to dance with GDPR. That's still a question mark. But it is a direction that the U.S. is going in, but we are not the leader in this conversation. But the flip side of it, one would argue that we are actually the leader in the from the technology and the cybersecurity vantage point. So it's just. Any other questions? All right, I'm going to keep moving forward. All right. So the next question that you have to ask yourself is: are you a controller or a processor of information? And anyone who's been doing this for a while knows that in the past, the 95 directive focused on controllers, and processors were actually not the focus of 95. Now GDPR makes it so that controllers and processors are both now under equal scrutiny. And so the way that let me explain what a controller and a processor is. So a controller is an entity that actually is in control of the data. So in other words, they're not the originator of the data, but they're the primary collector of the data, and they're the ones that hold on to it. A processor manages or moves or processes the data on behalf of the controller. So it's so you may, by way of example, you may hire or enter into a contract with a credit card company to be able to supply you with certain credit card services, and they would be processing your clients or your customers' data on your behalf, right? So, and that under that circumstance, you would be your entity would be the controller of the data, and then the credit card company would be your processor. So, and in many ways, it's not uncommon to be both. Okay, so you have to be able to kind of map out exactly how your data is being used, and making certain that you actually have the right contractual obligations in place. So, so again, more detail. If you maintain records, you're a processor. If you maintain records of personal data, you are required to maintain records of processing activities. And again, Ash will talk more about that. This is a new nuance. Maintaining the records of processing activities, or being able to demonstrate that you are processing properly, and then you're liable for a breach of any of that falls under the processing requirements under GDPR. Oops. And if you're a controller, you're not relieved if you're of what your processor, if you have a processor involved. And before, there contractually a lot of obligations were pushed down to processors as a means of, as kind of managing risk. But now controllers are now held accountable for that activity as much as their processors are. And your contracts with your processors must ensure that you're making certain your processors are compliant with GDPR. So you can't just give it to your processor and walk away as a controller. So before I move on to the gap analysis, any questions? Does that make sense to everyone? I went backwards. Okay, here we go. So now we're going to talk about basically, you have as a corporation or an organization certain things in place. We all do. Cybersecurity and data privacy compliance is not new to anyone. It's part of who we are. It's been part of who we are for a long time. And so the question is, going to the second bullet from before, let's figure out what you have in place and leverage it. So you have to know yourself, and you got to leverage what you have. Okay. So now what we're going to do here is that we're going to talk about, in this gap analysis section, what is missing, most likely missing from your current environment. Okay. And this is high level stuff, and obviously everyone's different. But anyway, so with corporate compliance and culture, basically GDPR is a business decision, and it's a top-down one. You have to make certain that you have your senior management your board, your senior management has got to be involved, and it's got to be agree with what's going on in your world with GDPR. Make certain that it's got to be pushed from the top down. Secondly, it's interdepartmental. It's no longer where you hand it to IT and then throw in a legal person and you say, okay, fine, you're done. IT cannot carry this by themselves. Legal cannot carry this by themselves. Marketing and sales have to be front and center because that's where your customer data is. HR has to be front and center because that's where your employee data is. Procurement has to be front and center because that's where your third-party supplier relationships are, and you have to assess them. And not only that, makes sure that contractually that they are doing the right thing. Quite frankly, M&A is another one that needs to be a part of this. Your front office needs to be a part of this, which was part of sales. And then finance and audit also have to be there as well because, again, there's this issue around making certain that ROIs are properly balanced against what this new requirement is going to be, and so that everyone understands that from an efficiency perspective, and then also auditing, because quite frankly now you're going to be open to having many data subjects, and now all of these EU authorities be able to audit your activities. So everyone's got to be on the same page and come up with a strategy that fits your organization. Educated while you're doing that, you're educating everyone, and your common gaps, which brings us to common gaps. Your common gaps basically are that your culture may be cybersecurity centric as opposed to data privacy centric, and that's just because we are, if you're a U.S. company, that's just the default in the U.S. And so you're going to have to make a little bit of a shift to make certain that the culture understands that this is beyond just like technological solutions to be able to become compliant. And then the other thing that's also going to happen is not my job. You know, everyone's going to say this is low-hanging fruit. I don't want to do this. This is annoying. It's all the things I don't want to have to change the way I do my day-to-day. But the reality is everyone has to join in for you to be successful. The second place is for a gap analysis is the regulatory and other legal frameworks. Here, what we're talking about is I just list a number of very popular places where we've all been before around that deal with your current information governance programs. FTC has been active since the 70s, SOX, Gramm-Leach-Bliley, HIPAA, PCI and COPA all are 1990s and early O's, 95 Directive 1990s. And basically, so that means that organizations have been addressing some form of cybersecurity and also data privacy and under these other regulatory frameworks. There are going to be common gaps associated with the fact that you have these programs in place already, but now they have to be expanded or elevated to be able to also be responsive to GDPR concerns. Those common gaps include you're going to have to expand your definition of what personal data is. As we mentioned before, it now is including things that we would deem to be a little more intangible. Biometrics, by way of example, is a key area. Other types of things that one might use to identify an individual, even whether directly or indirectly. So, you know, you look at 5 different variations of 5 different key points of information around a person, and you can figure out that, oh my goodness, that's Donna. That is now not allowed unless you have a regulatory reason for doing it. Data subjects, another common gap. Data subjects rights, actually, especially for non-HIPAA environments, may be a new muscle for your culture. You know, having individuals, you know, be able to opt out and ask for all sorts of other you know, information from you, and you have to respond at the drop of a dime, basically, to maybe not part of your current regulatory framework. Data collection, modification, and erasure controls. Again, this is an extension of the data subject's rights. Training requirements. You're going to have to make certain that your workforce actually has a clear understanding of what this new world. And they don't use muscles that are old and are not responsive anymore to your GDPR requirements. You know, Ash and I have actually seen this happen in real time recently, where we're getting these assessments back where folks are like, oh, it doesn't apply to me, and they're using criteria that doesn't even make sense. It doesn't apply to GDPR at all, and you have to explain that, you know, the way you're looking at this is just it applies to the U.S. version of protection and not the EU. Audit trails, you have to make sure that you're able to audit everything that's in your space, and you have to be able to demonstrate that you're actually compliant. Ash will talk more about that, but that may be not part of your environment right now. And then updating related workflows, policies, procedures. A few new things that are just brand new, they're not even gaps, they're just brand new that we're going to have to start to think about, is to determine what degree you're able to lawfully process data. We talked about that earlier. And you're going to have to stop processing data that you're not legally authorized to process or to ask for. And then you have to establish ongoing explicit consent programs. Again, policies and procedures, you already have a number of policies and procedures in your environment. All of these policies and procedures are going to be touched by GDPR, and you're going to have to make certain that these policies and procedures actually are updated to deal with data subject rights and requirements. And brand new there's certain GDPR specific policies are going to have to be put in place to be able to make certain your environment is compliant. Next part of the gap analysis is contract and relationship management. Here, you have in place as an organization contractual relationships, contracts and contractual relationships. If you're left over from the 95 directive, you probably have a program around controller and processor agreements. You also have supplier agreements with your procurement department, generally customer agreements out of your front office, counterparties and NDAs, inter and intra-company agreements around how information or intellectual property or assets just flow between your various affiliates. You will have negotiation roadmaps around how your employees are supposed to be negotiating these agreements and making certain that they're all hitting uniform requirements for the organization. And then you also have global normalization activity to make certain that that your offices in Japan, Peru, and in the U.S. are all operating off of similar assumptions and rules associated with how various contracts are negotiated, but also then globalized to make certain that they're lawful in those individual jurisdictions. Now, with GDPR, there's the gaps that you're going to find here, or you're going to have altered or new processor requirements and obligations, and you're going to have to update your agreements accordingly, as well as any negotiation rules and also global normalization. You're going to have to make certain that all of these agreements entertain and account for new data subject right requirements, and you're going to have to normalize between all of your contracts and templates and your workflows, training, supplier assessment programs is a big one. Supplier assessment programs basically are already required under a number of the regulatory schemas we've already discussed that are based in the U.S., but now there's another level of standard associated with supplier assessment programs under the GDPR.
Question.
Yep.
For supplier assessment, does that include software as a service where you have like cloud-based platforms that house your data and then do analytics on just like a general population and expense management? Like Concur would be an example where they provide like industry trends and reports based on all of their clients' data. So how would that fit into this regulation?
You're supposed to be assessing all of your suppliers under a number of regulatory schema. So if and it sounds like to me that particular scenario you just gave with cloud service providers would fall under just general regulatory schemas, and it definitely sounds like it would fall under GDPR if they are touching your data subjects information. That's the key. So if you're hiring somebody to do something that has nothing to do with your customer information or your employees' information or any information that's within your rubric, then you may not have to assess them from a GDPR perspective. But that's a hard one to kind of imagine.
Touch it on the technical side. We have a slide deck for that.
Okay, perfect. All right. Just to bring home, I only got a couple more slides on the gap analysis. So these are your data subject rights. We've hit on a number of them already, but I'm just going to run right through them real quickly. So they have the right to, they have to be able to use any information from a data subject, you have to have explicit consent. And that means that you no longer can really just do this hidden I accept button. You actually have to have a pop-up that actually, and you probably are seeing this on a number of websites right now where there's a pop-up and this is, before you even enter the site, we're about to ask, take some of your personal information, is that okay? And the data subject has the right to click, just ignore it or say yes or no. And that is the type of level of consent that is expected before you collect that kind of information from an individual. You can belt and suspender it into kind of like an I accept button, but it's not going to be, an I accept button will not work anymore on its own. The next data subject right is transparency and clarity. What that means is that you have to be transparent about how you're collecting the data, and it's got to be clear. And if you're ambiguous about any information you're taking, then that's going to put you on the wrong side of the GDPR. Access to the data, they have to be able to access anything you collect about them. They have to be able to rectify anything they see that is incorrect. They have the right to be forgotten or to ask you to erase them from your systems. And then they also have the right to restrict the degree of processing. So in other words, what are you doing with my information? And no, I don't want you to rebundle it and sell it to so-and-so. So they get to say, you can only use my information for this specific purpose to be able to supply me to these specific services, and that's it. You have to notify them with any changes that you're making around their information, and that notification process should be automated. Again, this is all of these things should be automated, quite frankly, and Ash will talk to that. Portability, they get to be able to say, I want to take my information with me and move to another vendor. By way of example, if you're on one dating site and you want to move all your profile and everything to another dating site, you get to call up the first dating site and say, lift and load all my stuff, I'm moving it over to so-and-so's site. So that's portability. And you have to be able to provide them with information, a way to be able to make it portable. They have the right to object to any data you're collecting. And then automated decision-making and profiling rights. Again, if you're starting to kind of put this data into an automated system that allows for them to for them to be profiled or identified, but once it's all collected together, before it was separate, now it's all collected together, and I was like, yep, that's got to be Donna. Then that is deemed to be a right that I get to make a decision around, not you. And so the common gaps here are just basically your processes, your policy, and your training, and your technology should be listed there. Sorry, all need to be upgraded to be able to address this. Any questions?
Yes, we have one webinar attendee. What about donors? People that donate money online for an online movement.
That information is deemed to be, the question was asked, what about donors? And basically and any information given by a donor to a cause online, yes, your information would fall underneath this rubric. Definitely the GDPR applies to all organizations, whether they are for-profit or not-for-profit. So the charitable intention of the organization does not impact the fact that they have to be GDPR compliant. And if you are the data subject in that scenario, you also have to make certain that you have all these rights that we're talking about right now. Any other questions? Yes. Sorry.
Under Regulation 95, if an infraction is found, then the culprit is subject to fines or sanctions by the EU. Is there any private right or private cause of action?
Where they can go to you directly? That's a very good question. The answer is, I
Probably
think
no.
yes. You think no? You think that they have to go through the regular? Here's the reason why. Maybe this is an
I
offline
hope you're right.
conversation. Yeah, no, but the reason why I think the answer is yes is because I also know that that entities who are, and this is perhaps, I apologize for the non-lawyers on the phone, but like by way of example with e-discovery, right? And you are collecting information to handle a case, and it could go either direction. You may be collecting information that the other side doesn't want released because of EU 95 reasons, or the EU wants you is bringing a claim saying that you can't release it under your litigation. And I've seen under those circumstances by a private individual and also by the authority. So I think that's the reason why I'm thinking that this could also have private implications. It has to. It seems like it would, given the fact that these data subjects have all these direct rights with you already, that they can cause you to do all these things. I don't see why they can't also say that you're infringing on their EU right. Their GDPR rights. Sort of like similar like with civil rights, right? You get to sue someone for civil rights directly. You don't have to go to an authority to be able to claim civil rights, violations.
The reason I asked is I got approached by a long-standing friend who had purchased a timeshare in Mexico, and the friend was recently scammed.
Oh.
Lost a substantial amount of money. And my theory is that the timeshare company didn't protect the information.
Therefore, absolutely. Under that scenario, I wouldn't be surprised. Yeah, absolutely, there would be a claim against the timeshare entity. That's a direct violation of the GDPR. If they're not, because of the fact, if they had adhered to the GDPR, my information would not have been released to. Yes.
Because if I don't have a regulation or a violation, it's very difficult. And then I have to begin a suit, and I have to prove that the information wasn't protected.
Mm-hmm.
But if I have a governmental agency or some agency like the EU find a violation, it becomes much easier. There's not enough involved to get to start a suit in Mexico or retain a lawyer in Mexico City.
Well, each authority has the right to hear complaints and to also act on behalf of data subjects in the protection of their rights under any infringements against their rights. So the GDPR gives the authority that authority, but it's a question of whether each member state, because each member state is the one that creates their own authority, and the question is whether or not they're going to follow suit 100% or whether they're going to taper back what their responsibilities are going to be. So
Mexico's not a part of the EU, but do you know whether or not they have any regulations pertaining to protection of personal information?
I am not familiar with Mexican law around that, but I'm quite certain there's got to be something. I can't imagine that they're just kind of blank at this stage in the game. Every country has some form of, some level of protection. To what degree, I don't know. But, all right. All right, this is my last slide before I hand it over to my colleague, Ash. And this is about the data protection officer. It's mandatory if you have 250 employees or more. It can be outsourced, so you don't have to bring in these resources internally. And basically what a data protection officer does is they are responsible for seeing that your organization is legally compliant based upon risk appetite, data maps, IT infrastructure, and risk assessments. So it's a muscle that needs a legal oversight, but at the same time, to do it properly, can't be done in a vacuum. It has to be done with an IT partner. And basically, the data protection officer approves the data subject consent and other right management programs that you are putting in place, and it approves the thoroughness of your PIAs or your and PIA stands for privacy privacy information assessment, and which is a kind of a standard today that a number of regulatory schemas, the SEC is very big on PIAs. Basically, it's a way of assessing your environment to make certain that you actually are protecting folks' privacy appropriately, and usually it's the first step. And then what happens is that if your PIA requires under the GDPR, it triggers certain needs under the GDPR. You may also be recommended to execute what is called a DPIA, which stands for data privacy information assessment. I'm so sorry, I'm just tired. So anyway, but with all that said, but the DPO would be the person to make that assessment for the organization. Lastly, to talk about the gap analysis here, if you do not have a privacy officer, if you do not have a CISO, then really this is the function that your organization is going to have to build. And any other questions before we move on to Ash?
Two questions.
Okay.
One is the equivalent of a privacy officer for HIPAA?
HIPAA? Yes. It depends upon your organization, but in many ways, this would be an extension of that function, because the thing under HIPAA is that HIPAA is very geared towards protecting individual privacy. And so if your privacy officer is already doing HIPAA activity, then GPDRs is going to be one step of a little more complexity, but at the same time, it's basically an extension of the same muscle.
Another question is, where does the liability fall on the company assessed or the company doing the assessment in terms of a set violation?
It depends upon. It's a very good question. The question was, where does the liability fall when for vendor third-party assessments, third-party supplier assessments? Basically, is it the assessor or the one that's being assessed? And the question really is that both parties have a certain level of obligation under the GDPR. So if, by way of example, if the organization that hired the vendor did not properly ask the vendor contractually and also through policies and programs to make sure that they are GDPR compliant, then and that would be deemed to be a violation on the part of the organization. And if the vendor has been put on proper notice by the organization and still is failing in their GDPR compliance, then they're the ones that actually are accountable. So again, you're going to have to make certain that your risk assessments are, thinking in a 360-degree perspective.
And then one more online question is, do they need any certification for a DPO, or could they simply be appointed by a policy and procedure?
The DPO does not need any particular certification at this point. The authorities have the right to ask for certain levels of qualifications, but they're not. The one thing, though, is that your DPO really needs to know the space. You cannot just give it to somebody who is going to learn on the job. You really should find somebody who actually understands security, privacy, contracts, how your organization runs, or how sophisticated organizations run. They have to have a really 360 full sphere understanding of what your organization does, what the law is around all of those different areas, and also this can't really be their first rodeo. I wouldn't recommend it, so. Any other questions? Yes.
What does an outsourced DPO look like? And does that have to be an individual? Can it be an organization? Do you provide those services?
Yes. Yes, I do supply those services. An outside DPO is generally an individual that actually has a number of tools at their disposal, so that they can basically replicate for you a full understanding of your environment. There are organizations that supply these services. There are individuals that supply these services. They should, as I said before, they should be well versed in the subject matter area. The nice thing about outsourcing to a DPO is the fact that they actually see a number of organizations so that you're getting industry standards. And being able to benchmark yourself against others. Of course, your DPO should be operating under confidentiality and ethical walls and all this other kind of stuff to protect you, but at the same time, it's nice to be able to have confidence that you're growing with the industry and best practices. Okay, with that said, I'm going to pass this on to my esteemed colleague, Ash Marcos.
Will you be sharing these slides?
Yes. Oh, yes, we will be sharing the slides. That was the question asked. Yes, we will be sharing the slides afterwards.
Thank you, Donna.
Mm-hmm.
All right. Welcome to the fun part of GDPR. I'm going to talk about technology. How do we convert all this, the legal aspect of it to a technology where you can apply, it makes sense, and you can produce the what's required. So before we begin, how many lawyers in the house? Okay. How many technical people? All right. Do we have any marketing people? Okay. So all this is caused because of marketing, right? Marketing loves to collect data, right? And they want to use that data to sell us, upsell us, put information to us. So from a technical perspective, we need to understand what really GDPR is asking for from a legal perspective, and then we need to convert that to a technology. There's so many technologies out there that you're probably using already today that you can leverage. But you need to tweak it in a way that what GDPR is asking for. So for the technical guys, for the business guys, it is really important that we understand the legal aspect of it and map it to a particular article. So in my slide deck, I'm going to share, I'm going to specify for this technology, you got to refer to this article, right? So very first thing when you start with GDPR, right, you want to know where your data is, right? What are you collecting? What is your business is collecting? If you're a DBA, right, you have a SQL database, or you mentioned Concur or any of those SaaS-based application, what type of data is the business collecting, right? The legal team, the compliance team, they need to give you an understanding what type of data they're collecting. And then from a technology perspective, you need to somehow map that data and understand, is that data a personal data? If it is, then you have to flag it, right? The slide is a little bit fuzzy, but from a technology perspective, right, this is what it's going to answer the GDPR, right? So let's look at the who. Which department is in scope of that GDPR, right? HR is one of them, right? Marketing is another big one when it comes to GDPR. So you need to understand which department within your organization is collecting personal data information, right? Like I said, most of this technology, you already have it. But again, you need to map it to a personal information. What is the source? How is this data coming into your system, right? Is it a credit card processing? Is it personal information? Is it an employee survey, employee salary, or you have a marketing campaign, or you can subscribe on your website, right? You need to identify how that's coming into. And then you need to understand where it's being stored, right? Then this comes down to your question, where you need to find out where is it stored. Is it you that owns that system? Is it another party that owns that system? If it is another party that owns that owns system, we'll talk about it later on. You need to do a third-party risk assessment, right? And that third-party vendor risk assessment need to be specific to privacy, right?
So like with this slide, if you added why, would you focus on the use case or the thing that interacts with that particular department, like human resource, employee onboarding and like offboarding? You'd set them up in whatever your HR management system is, and then maybe you have to, there are like other systems that are connected by way of each of the departments.
Yep.
So do you look at it from the perspective of the department? Like what is the starting, is that the starting point, or is it like the activity? Like I have a new employee, I have a new client.
Yeah. So this is the data mapping portion of it, and we're going to get in detail into it. And then the why questions also will start coming up, and then how you're mapping the data. Yeah. But the most important part is this action, right? At the end of the day, GDPR is going to ask you some kind of action, right? And this is, we're trying to find out, do you confirm that you have this actually personal information? You know, how are you protecting that? Are you encrypting it? So we're trying to convert the legal aspect of it into a technology that's more relevant, right? And then also you got to remember, not everything is going to be covered in technology. GDPR is very wide, very general, right? And you have to prioritize. Okay, where are we going to focus on, right? So again, this is a quick snapshot to give you some of the GDPR articles from a technical perspective, right? We're going to get deep into it, but some of the stuff you probably already have. You probably have data security, right? If you have a data security, how is that relevant from a GDPR perspective? So Donna talked about gap analysis. This is the technical gap analysis where we're going to address, all right, you have data security. Is it, and does it map to GDPR requirements? If there is a gap, that's where we're going to address the gap, right? Data governance, data subject rights. So some of this technology, you should have it. If you don't, then you can start from scratch. But if you have it, then you're going to leverage what you have. So one thing that GDPR is calling out, and from a technology perspective that we need to focus on, must demonstrate, right? What that means, right? Basically, an organization has to demonstrate that the articles that you have from a legal perspective, you're enforcing it using a technology, right? Do you have incident response, right? How is that from a technical perspective, right? How do you know you have a data breach, right? What tool is going to notify you? It's not going to be a person that's going to say, I'm going to notify you, right? There was a question asked, how are they going to enforce it to us? Are they going to go for the big fish? They're going to focus on, if there is an incident, right? They're going to focus on that incident. Right? So if you're a big or small organization, if you have actually an incident, they can come after you and say, hey, I want to look at the whole process that you have. If you collected someone's data and they ask you for it, and you don't have a mechanism to process that data or delete that data or get that data information, that person can report it, right? That could trigger an audit. But so coming back to this, you have to have some of the technologies in place to demonstrate that you're doing it the right way, or at a minimum, you're following their guidance. So I'll pause here for questions.
What's that reasonable level of protection that you is that a gray area pretty much?
So it's gonna tie to a risk assessment. So you have to conduct a risk assessment. You have to identify, okay, from a risk perspective, if that data get compromised. So let's say you're collecting sensitive information, but it's encrypted, right? So you're we'll touch up down the road. then your risk is low, right? Because you have sensitive information, you've put all the safeguard, right? Then your risk is low. But that's from a technical perspective. Now, from a legal perspective, that could be different. So that you have to balance this too. And
So I guess if you get a notice where you have to provide proof, we don't know what that criteria is yet until the first company comes along and gets audited, I guess. Like, we don't have like a general standard where we show proof that you're logging transactions of this, show proof that you're encrypting this. We don't really have a cookie cutter question and answer.
There isn't, and I have a slide deck. It's you have to right here, the one in green, right? So you have to follow industry standard, right? They're asking you to follow like ISO 2700, and there's specific how to protect the privacy. If you're following that standard, and you still got a breach or something, incident happened, you did your best, right? So then you should be okay in that.
So,
I don't want to say you're trying to do the right thing, but if you're not following any standard and you're just you could be in trouble.
I guess do they specify which?
No, they leave it very general. They say use best in industry best standards.
Okay.
Right.
Yes, you got it.
Yes.
Or would Regulation 95 apply to a very small organization too? Let's say a 2 or 3 person organization?
As long as you're collecting personal data information, it will apply. It doesn't matter the size of the company.
And from the webinar, oh, sorry.
Yeah, it would seem that almost any organization then would be covered.
Correct. If you're collecting, yeah.
If you receive an email and save the emails.
If you're using it for commercial purposes.
If you're processing that email to do something with it, yes.
And on the webinar, Wesley says, so standards in U.S. would be applicable, maybe even down to the level of U.S. states?
And more information.
Like the NIST framework is probably maybe what they're referring to.
Oh, yeah. So I mean, you can use the NIST framework. There is privacy information within NIST that you can leverage. Yes. It doesn't have to be ISO, right?
Thank you.
Any other questions?
I think it's challenging. Like how this seems to block a lot of the advances being made using data and like the direction that industry is taking to collect and mine information to provide outcomes or tools that will benefit the future, like, you know, the disruption model. And it seems like this would be a block to those smaller companies that are trying to innovate.
This is, yes, for anyone that's big data, right, this is a big problem, right? You know, well, in the U.S., right? In the U.S., we just collect everything and you try to analyze it and come something to do with it, right? But like all these car sharing companies, they're gonna have a huge problem in Europe. Right? They're collecting your information. They're, you know, they can analyze all the rights that you took, but now they can't do that.
They can if you provide consent.
Yes. But
Yeah, like Google, for example, you can tell them exactly what you want them to watch or not watch, but if you don't give them your address, you won't get Google Map directions. So, you know, but you give it to them voluntarily. So,
Yeah.
But yeah, it's a gray area for sure.
Yeah.
A lot of companies.
I guess the triggering term is mining the information. So how is that defined? Because all of us collect certain information.
So, like he said, it's going to come down to you got to inform them why you're collecting that data and what you're going to be doing with it, right? And as long as they're okay with it and they accept it, then yes, you can process it.
Suppose you don't do anything with it, then you wouldn't be violating the mining.
No, you're still storing it, right? So there's data retention, how long you can keep that data. You have their data. So there's data storage, right? How long you're going to keep their data? What are you processing that data to sell it to something else, right? You need to inform them. So that whole consent is a big portion that you need to explicitly specify what you're going to be doing. If you're just storing the data, you need to explicitly say that you're just storing their data for future reference. But at that point, when you're using it, you need to specify. So that's the legal portion of it. From a technology perspective, we can store it and process it and do a lot of stuff with it. And technology companies want to do that, actually.
I'm a lawyer, so I get information from clients, sometimes Social Security numbers, which I need, but I'm not going to transmit that to anybody else. But would I be covered by Regulation 95? And I'm required to retain certain information for a certain period of time, too.
Subjects from Europe.
Yes.
From Europe, yes.
European subjects.
Yes.
European subjects.
Maybe something you have to ask when you collect that data. Are
Yeah,
you
that's correct.
in one of the European unions?
Sorry, last question. Are there any exemptions? Like, for example, if you're an attorney or you're a doctor and someone asks you to get rid of their records, then it's impacting your ability to practice or to do your job.
Yeah, no, there definitely are exemptions, and that's part of the having to sit down and look at the full picture and figure out what is your cocktail around what can you keep, what can you process, what can you destroy, and what you should be destroying because it's not part of your business model. So, but yes, for regulatory purposes, if you're allowed to keep and manipulate information, you just have to make certain that your customers know that that's what you're doing with their information.
That's part of like that consent checkbox. Like
Yes.
if you don't consent, then we can't really provide you services. And
Yes,
have
exactly.
a good day.
So
Exactly. No, that's
Let's
exactly
say I go to the EU and I'm meeting company A. We're going to do business together. Typically, my firm will draw up a contract with that company, and we'll get like 8 people in their company who's part of that engagement, and we collect their data and put it into our Salesforce CRM or something like that. I am supposed to notify every individual that go into my CRM individually, or can that be covered by a contract? Because one of the things with this new rule is you're supposed to make it very simple for the data subject to opt in or opt out, I guess.
Yeah.
How do I do that in that scenario? You know, what would I do technology-wise? I don't bring my data subjects in that example to my CRM. I enter them into my CRM. So what do you do?
We went to the GDPR training yesterday. So one formal is consent, right? The subject has to acknowledge. But in this case, you have to have some kind of contract. There has to be something other than consent that you're collecting that.
Something reasonable.
So,
Yes.
I guess would you just tack on a privacy statement with it, and then give them some information like contact us at this address if you don't want to.
There are many ways that you could slice it so that you're compliant and that it fits your business model. So that's the whole thing. And maybe in your scenario, you would be pushing that responsibility down to the vendor as opposed to you having to do it. It really requires that you kind of think creatively and make sure you're not taking on too much additional.
And then we're going to touch on privacy by design.
Yeah.
So at some point in your design process, you have to say, okay, am I collecting any privacy information from Europe? And then how am I going to incorporate it into to become?
That doesn't intent matter. So in his example, in his CRM, he's capturing information, name, email, company. If there's no intent to market to that individual. It's just point in time I had a meeting with someone.
Right.
Right.
Yeah.
As opposed to having that then roll into a digital marketing campaign that will run for perpetuity. So my understanding is intent plays a part in this.
Yes.
What you are planning to do with the information. It might be personal if you are doing nothing with it. I mean, maybe that's not explaining.
You're right.
it
So
clearly.
intent ties to risk assessment, right? So you have to, what are you going to do with that data? If it is just you're going to collect this for meeting information, and after 5 years you're just going to destroy it, then the risk assessment is going to be very low for that, right? You have to tie it to a risk assessment. But if you have a plan to process that data, right, and maybe that processing is going to go to a third party, that risk is now higher, right? So it's all risk based.
So the question is, what is Salesforce on the back end maybe
What are they
doing
doing?
with this information?
Yeah, and then
That
this
maybe
is
none
also
of us know about.
Right.
yeah. So what Salesforce, any SaaS-based application, we have a slide deck, probably more on the Microsoft side. Most SaaS-based applications, right, systems, they have their own GDPR component, right? They have their own compliance. It's a shared responsibility when it comes to cloud, right? So they do their own part, and then there's your part. So
Part
they
of the
yeah.
third-party diligence.
So they have to make sure that your data, they don't see it.
Yeah.
They're just providing you the infrastructure, the platform, and they will have to give you some kind of information saying, and that's part of the vendor risk assessment. We're not processing your data. We're just helping you store it, and here's the level of protection we're giving. And then they will tell you it's your responsibility who has access to it, how you're going to process it. Yeah.
As a lawyer, I deal sometimes with a European client, and I have an escrow account, and those accounts are heavily regulated by the appellate division. But I do collect very personal information, but there's no intent to give anybody else the information. In fact, the client is protected by the attorney-client privilege, so I assume that I would be okay.
So assumption, at a minimum, if you're collecting data, you have to refer to Article 25.
Article 25.
You must, you have to have some kind of safeguard, right? Somehow, even if you're not going to process it, you need to make sure that data is protected, right? Yes, your intent.
I think I'm okay because I deal with Citibank, and they give me a token and passwords, and I always forget the passwords. It's protected.
So it's going to
I
come
can't
down
even get
to
it.
this. If you get audited,
Yeah.
you have to demonstrate that you're safeguarding that information, so you can document.
I see.
You have two-factor authentication. Citibank is the one that, and you have to do vendor risk assessment with Citibank, right? So you have to demonstrate that you have a safeguard, and then you should be okay, right? And you're an attorney, so you have to do the legal aspect of it.
I think I'm okay because Citibank has a lot of safeguards there, but for me to, in a small firm, I'm a sole practitioner, to go through this is very onerous.
It is.
Okay.
On the technology side, most technologies are there today. So it's going to come down to, let's say you download all those information to your laptop, and then you lose your laptop. What happens at that point?
Well,
right?
I dealt with a client who lost about $250,000 sending an email to someplace in Nigeria which never existed, and the information wasn't protected.
Yeah. So there are some level of,
and that resulted in a federal lawsuit on who was responsible and who should have been protecting it.
Right. Well, we can actually, glad to have a sidebar with you on that. We probably only have, we have a lot of slides to get through, so we should probably.
Oh, I'm sorry.
No, but we're glad to have a sidebar.
All right. I touched on this. Article 28 says, right, this is a vendor risk assessment. Right? From a technical perspective, there is a lot of vendor risk assessment. Most companies today, they do some level of vendor risk assessment. If you're already doing vendor risk assessment, what you need to add on is you need to identify what type of data are they collecting, and then you have to specify, okay, you're collecting personal information from EU. How are you protecting it, right? So this is an add-on, and if they're not from a technology perspective, then you're gonna have an issue here. A touch bit on this one also, Mess Secure, right? So you need to make sure that once you identify what the data that you're collecting, you need to make sure there's some level of security. So I mentioned it here. Citibank is protecting it, but also are you protecting your laptop? So you need to make sure if you're downloading that information, that sensitive information, your laptop is encrypted, right? So you have to add some level of security on your side. So some of the heavy technical requirements are like Article 32, right? They explicitly call out for confidentiality, integrity, availability. This is a NIST, ISO terms, right? Again, it comes down to the industry best practice. You know, what are the confidentiality that you're applying, the integrity of the data. If somebody goes there and changes that data, right? You know, you have to have a mechanism that data doesn't change. Availability is the key one, right? This is more like if the system is not available, right, and the data subject can't get to it, right, you could be liable, right? Most people don't see availability as a security. It's more like a disaster recovery, or the system should be up and running. But if that system is down for extended period of time, that means that subject is person is not being able to access it, can trigger that audit. Right. Touch base on this one too, right? So this is any type of interaction with a European data that you have, you want to apply privacy by design, right? You want to say, okay, I'm collecting this data. What are the privacy security that I'm applying, right? The key part here is privacy, right? That personal information, how is it being processed? If it is being processed, how am I going to protect it? And then this is the question you asked earlier, right? The data mapping, right? The data mapping is going to be the critical one. Where is your data? Right? Is it on Salesforce, Concur? Does the data move? Right? You know, Concur is your expense, right? But it has to tie to your SAP, right? It has to come back to your HR. It has to come back to your payroll. Right? You need to map all that data. And how is that data moving? While it's moving, is it changing? Is it being encrypted? Is it being protected? So you need to have a data mapping exercise. And you need to make sure that there's privacy by design around it. You have to layer it with vendor risk assessment. And then you have to have some kind of the legal component wrapped around it. And then there's another section where we're going to talk about incident response. What if you have an incident in Concur or in your Salesforce? How are you going to trigger that? And the incident response that GDPR is asking for is completely different from the standard incident response. They're explicitly asking was there a privacy breach, not like, you know, the system got breached, but the data was okay because it was encrypted, right? Then you don't have to report it, right? But as part of your incident response, you probably have to notify that to a different compliance. Right, so this is where the why comes in. Remember, you were asking for the data mapping. So basically, you need to answer these questions with every data that you have identified that's going to be in scope of GDPR. Right. And then I highlighted this 3 articles from an assessment perspective because it touches a lot from a technology perspective. Right? They call out explicitly record management. Right? This is, you know, even in the incident response plan, right? You can have incident response plan, but they want you to have something that you can demonstrate. When did the incident happen? Right? How did you filter it out? How did you identify this was actually a a data that was compromised? How did you notify the data subject or the authorities? Right? They want that in a recorded, in a workflow type of environment. Like it can be as simple as Excel, but they want to see the data, that whole process, right? They want to see logs, right? From a data integrity perspective, who changed that data? A data subject can actually ask you, did you change? I can put a request to change or modify my data, and then I can come back and ask you, or if you get audited, did you actually change this data, or you just said, yes, I changed your data, or I deleted your data? You have to prove that. So GDPR is all about privacy, right? So one of the very first thing you need to do is privacy information assessment, and actually this is the one that I was talking about. It's all based on risk, right? So you need to identify if you're going to be subject to Article 35 and 36, right? So this is a workflow. Are you the data that you're processing, does it have high risk, right? If it doesn't, then DPI might not be required. Maybe you're just storing the data, right? Again, from a technical perspective, we're taking a legal, the legal workflow, saying, okay, you're just processing, you're not processing it, you're just storing it. Okay, we're going to store it and encrypt it, right? We're not going to do anything. Oh, you're processing it, and then this data is moving between different platforms, right? Then the question is different. Right now, you have to apply different type of technologies. And then, whether you have incident response policy, or if you need to create one, right, and need to focus strictly on privacy, right? You need to update your incident. Most companies can say, I already have incident response policies, the whole thing is in place, I don't need to do it. But GDPR explicitly calls out for privacy. They don't want to hear about your system being breached. They want to know which data got breached, right? And then you have to make the determination whether you need to notify the subject depending on the risk, right? So there's two notification and incident response, right? The DPA has to notify. So whoever you appointed as a DPO, or whoever the going to be the chairperson within your organization, has to notify the authorities, the closest. And then this is where the policy needs to be polished. If you have UK presence, Germany or Netherlands, one of this, right? You need to identify which authority in there you're going to be notified, right? And you have 72 hours to notify them from the time that you understand there was a breach. So if the breach happened to be on, I asked this question yesterday, if it happened to be on Friday afternoon and everybody's gone home, and Monday's President Day, right? That time kicks in, right? Especially for US-based companies, you're gonna say, oh, this not going to apply to me. It was a holiday weekend, right? It will apply to you, right? So every incident, this is a gray area, and you have to work with your counsel and legal team. They ask you to notify the authority for majority of the incidents, right? The data subject doesn't need to be notified unless it is a high-risk incident, right? Again, this one you have to closely work with your legal team and the authorities. But from a technology perspective, we have to make sure that this is in place to differentiate, the type of risk. The type of breach that occurred, right? Whether it's high or low or it was a medium, and then we have to give the appropriate information for the decision makers. I'm going to pause. Yeah. So I'm going to pause like for 1 minute. Any questions?
Just so you know, we have 15 minutes.
Okay. And then we talked about So we picked Microsoft since they sponsored for this facility, and we worked very closely with Microsoft. I think there was 1 or 2 Microsoft people here. So Microsoft is another SaaS. They have a bunch of products that collect your data, right? They have cloud-based, on-prem, right? And most of us, we use it. We use it for the email system, right? How many people use Office 365? Right? Majority of people use Office 365, right? We talked about what if I get an email, is that going to be part of within the scope, right? Is Microsoft processing the data that I have? If you have Azure SQL, is it only you that have access to it, or is Microsoft processing that data? If you're doing third-party risk assessment on Microsoft, what is Microsoft providing you, right? So Microsoft took the initiative, and they have extensive information around GDPR on their system, right? Not only GDPR, so if you have HIPAA, ISO, if you're dealing with the federal government, they have majority of those information ready for you. So as part of your vendor risk assessment, you can easily plug it into it, and you can take most of those information. All right, so this is a build-up. These are the services that they provide, and they also map it out to if each of them are moving around, right? One thing that keeps coming up in GDPR is data residency, right? Data residency especially is going to apply for Germany, right? So if you have a German information that you need to keep it within Germany, right? So Microsoft has a data center, you create Office 365 specifically for that region, right? And that should meet majority of your data residency.
And Azure.
Yeah. And Azure too, yeah. And then one thing that Microsoft did, they really simplified the GDPR, how it's going to apply to them, and then how it's going to be relevant to you, right? So the discovery portion of it. This is where you discover whether you're storing those personal data information. Whether it's within Office 365, they have a component for security within Office 365 that helps you with the data discovery. The e-discovery portion of it is one tool that you can leverage, right? Same thing with their Azure component. You can easily discover data that you have, and then you can map it out as part of your data mapping process, right? They have a manage. Basically, if you discover that you have a European data that's within that scope, they have built-in tools that help you with the encryption, the key management, right? That you can leverage. And then also you can apply security controls around those data, including integrity, right? And then finally, they can give you a reporting capability. So if there is breach at Microsoft, they can notify you, right? If there is a breach within your system, they can also help you notify you for that. So this is just going into the details, what Microsoft has and how it's going to be related to most of the documents. I'm not going to go. You guys are going to have this slide deck so you can get details. So at the end, right, the end game. Ronnie, you want to take this one?
Sure. The end game is to make certain that you have demonstrated compliance. There's you need to start off with really understanding who you are from a legal perspective, and then put in the right technological controls to make GDPR as painless as possible. As all the questions that came up online and in this room indicate, it is a little bit of a new frontier. It is broadly written, as I mentioned before. I don't really know how they could have written it any differently, given what they're trying to accomplish. So we will be going through a trial and error period. But because of the fact that GDPR has this kind of like no tolerance for not trying, component to it. You can't just wait and see. I mean, this is not. I mean, you can, but it's sort of like if you pull up the wrong straw, it will not work to your favor. Especially given the fact that data subjects have the independent right to come to you immediately on the 26th and start asking you for various requirements to be fulfilled. So, demonstrated compliance, you need a partnership between your legal, your tech, and all of the other stakeholders within your organization. Thank you very much. Yeah.
Time for more questions? Or?
Yeah, if there's any more questions, we have a few more.
Yeah, I have a question.
Okay.
So, for that data subject, is it best to just treat them all as if they're from the EU?
It's,
Because we may collect data on people now and not collect where they're actually from. And that would force us to go out and ask them.
Right. Well, actually, I'm so sorry to be distracted. Alan? Somebody asked online to have the sidebar with you. Do you have a second, or do you have to go?
What time is it now?
It's almost like 1:55.
50.
I have another meeting, but could you just get that person's name?
Okay.
And I'd be glad to.
Okay, fine. We'll do that, and then we'll
Thank
set
you.
up a separate call with you and him or her, and we'll go take it on from there. Sorry to interrupt. So. Yes. Should you be thinking along the lines of
Treat everyone the same.
treat everyone the same? That's actually not a bad policy. The issue is, do you have the ability to do that? But the reality is that some organizations are going to find it easier just to treat everyone the same. Right now when you see the websites, it's not like, are you from the EU? Click here.
Then you get 10%.
Yeah.
Okay. Because we, say we collect information, name, date of birth, whatever. We may not collect where they're actually from, so it's applied to them, really.
Right. So,
one other question. United Kingdom. March next year, they're no longer going to be part of the EU.
You're right.
Do you have to care about them?
Well, that's a very good question. It comes up all the time. The answer that I've been hearing is that basically, Brexit's a year away, as you point out, so the EU has to be compliant for the next year. So once they get up to that speed of compliance, and they still are very intimately involved with the EU, and generally, the assumption is that they're going to either create something very GDPR friendly that mirrors it, or it may just adopt it whole stock. So. But that's still a question that's in play. But the reality is as of the, for a year they're going to have to remain compliant anyway. So just do it.
Any other questions? No.
All right. Just one other thing to point out before we go. Maureen Data Systems and BurgherGray have put together a methodology to be able to supply you with cybersecurity and data privacy compliance support. We have a number of different models. We focus on trying to streamline everything so that we're not wasting your time, we're not wasting ours. There's less overlap that way. And quite frankly, we also are, our goal is to do this more efficiently, quite frankly, than you can, so that you feel that you're getting an extra service and an investment in your organization, as opposed to having it be where you're so that you can focus basically on your core responsibilities, and we can help you just remain compliant with confidence. We also focus on flat fee arrangements as much as possible, so that you can also manage your budget accordingly. So we would love to talk to any and everyone in this room and on the phone for a free consultation. We'll be able to show you exactly what we look like, supply you with a quick response back as to what we could offer you. So we hope that you take us up on that offer.
and hi, I know I just popped in, but just some of the things that we could offer when we start to think about, where are you today versus where do you need to be on May by that timeline. I know you spent a lot of time talking about the gap analysis, but we can help you put those things down in paper and give you an action plan and something to move forward with that you can start to implement or be implementing over the next few months, and then on an ongoing basis. So to give you something tangible for what you can execute against over the next months up until May, and then moving forward. So that's definitely one thing that we can assist you with now. And then there's a set of services that we can assist you with ongoing after that, should you require things like data protection officer or some type of monitoring services for any of the data that you're going to be ingesting, or obviously data classification, which is going to be a big part of everything you need to do around GDPR as well. So for those individual components, we can target those and provide services around them. But in the meanwhile, we can help you with establishing your game plan, helping you fill those gaps, what are the technologies that you need to do to fill those gaps, and give you both the technical and the legal backing for those particular answers and how you're going to get there.
Before you go, thank you very much, Michael. Before you go, we have a survey that we're asking everyone to fill in. And for the folks in the room, sorry about this, for the people online, there's a free sweepstakes, little gift for the winner. We'll just draw, independently. It's not the best answers get the prize. The issue is that if you can fill out the survey, and then we will give you a little parting gift, one person for completion of the survey.
You just hand them to me when you get that filled out, and I'll do the drawing.
Mystery box.
Mystery box.
You guys are missing the consent information.
Yes, we are. Well, it's not the 25th. We have 30 days. We have 3 months and 3 days. So, but
That's not the first time someone said that either.
Yeah.
The forms. Yeah.
It's not Europe.
Yeah.
there you go. We have all these excuses.
It did. I think the
Before
challenge
you go,